If you don't, if you want to wait till the end to see if I cover something and ask questions, there'll be time at the end for questions and answers as well. So, Gabrielle said that I concentrate on commercial matters, primarily construction matters. That is true, although this program tonight is designed for civil cases primarily. A lot of the things I'm going to mention, a lot of the things that I will be talking about have some applicability in family matters as well. I was here at the Law Center on Monday doing some training for the economic mediation program for the family lawyers. And so there are some crossover topics and crossover information that I will be able to, that you may be able to take away from this if your practice is primarily in the family law area. So let me start kind of at the beginning of the process, which is the engagement as a mediator with the parties. The terms of engagement, there are probably two primary ones. One is in the court-referred program, the mandatory mediation program. And in that case, you get a letter from the court with an order in it and a piece of paper that says, as of the date of the order, the parties and counsel in the case. From there, you have to go about assembling the parties, getting a mediation going, and you know, taking control of the process at that stage of the game. Some mediators, in addition to the court order, also prepare or circulate or ask the parties to sign a separate a retainer agreement or a separate agreement to mediate. Different mediators call them different things. I typically don't do that. I find that between the court rules, the Uniform Mediation Act, the standards of conduct for mediators, I think there are enough terms and conditions embodied in the court program itself and in the applicable rules that I don't feel the need to have a separate mediation agreement containing additional terms, or I know some people try to change the terms a little bit from what's provided in the court rule. I have not found it necessary to do that in my practice. So I don't, but it's something that if that's your practice, your firm's practice, I don't think there's anything wrong with it. Most of the time the lawyers will sign it. Sometimes you'll get some pushback, but I don't find it necessary to do that. So in terms of private mediations, again, those don't typically start out, although I'm trying to think how they typically start. Usually start out with a phone call or an email from someone who wants to inquire whether I'm available, wants to inquire whether they can talk to me about a matter. I'll get a phone call. I'll get either a phone call from the AAA or a letter from the AAA inviting me to conduct a mediation. Again, my initial action is to find out as much as I can about the case, about the parties. I will do that. I'll talk to either the lawyers. I typically schedule a conference call at some point fairly early on to be able to talk with the parties about the case and their needs and all. If I don't have any substantive information about the case, I want to find out what the status of it is. Sometimes it is a mediation sometimes it's a matter that's already in court. Sometimes it's a matter where it's a mediation is a condition precedent to arbitration. The parties may already be in arbitration and they backed off to go to mediation because their contract says they have to do that. Sometimes it's not a dispute that has been crystallized at all, and they just parties are having some issues and they want mediation. So in those situations, private, it is my practice to talk with the parties about the requirements, talk with parties and provide them with an agreement to mediate. It's not the settlement agreement, it's the agreement to enter into the mediation process with me. It's an agreement I have with the parties. A lot of verbiage in there about the authority. The key issues from my point of view typically are the scope of the issues. If there's an existing court case or an existing arbitration, the scope of the issues may be limited to what's included in the pleadings or demand for arbitration associated with those, with that particular dispute. I tend to have the document more broadly worded so that I can pretty much mediate anything that they ask me to mediate, whether it's within a particular existing dispute or not. I've had occasion where parties come to me mediating about one contract and we end up settling a different contract, other disputes that really haven't ripened yet. But once the parties are together and they're talking about making business decisions to resolve things, sometimes they'll expand the scope of the mediation to be a global resolution of a whole variety of things that weren't necessarily in the mix when we started. One very important aspect in an agreement to mediate is to deal with confidentiality. As I said, the court rules have a confidentiality provision in them. A lot of people think the Uniform Mediation Act has a confidentiality provision in it. The Uniform Mediation Act does not deal with confidentiality except to say the mediation process shall be confidential as agreed to by or between or among the parties. So it's important to find out from the parties and talk to the parties about what their expectations are in terms of confidentiality. The mediator privilege does apply in terms of my being called to testify in the subsequent proceeding or those kinds of things, but just, you know, what is confidential, what the parties' expectations are has to be spelled out in the agreement in order to allow the parties to rely on that confidentiality. Frequently in the discussion of documents to be exchanged or information to be provided, if it's a business dispute, there may be business sensitive records, there may be confidential business information that the parties agreed to produce. The parties may need to enter into a separate or include in the agreement to mediate the confidentiality of those records. Just as in court, sometimes there's protective orders protecting confidential information. In mediation, in order to get the parties to trade the information that they're looking for, that they each need to analyze the case and evaluate settlement options, they may need confidential information from the other side, and there are certainly ways to protect that. If you have, I can't think of a situation where I had an issue about confidential information where there weren't attorneys representing the parties, but I suppose if you had a pro se party, that might be a different issue. I haven't really had occasion to deal with that that I recall anyway. So the terms of the engagement, and again, depending on how the steps in the process tend to be the same, the order they're done, and depends really on how you get tuned into the case, how you get plugged into the case. So my initial process is to gather information. As I said, you get from the court, in a court-referred mediation, you get a piece of paper that says who the parties are, who their counsel are, what their phone numbers are. It doesn't give you their email address. You can go into the court website, the judiciary website, and get case information. The order of referral has a docket number, it has the county, the docket number includes the year of the case. You can go onto the court website and find information in there about the case. You can find out, the case type. You wouldn't tell from what the court sends you whether it was necessarily an employment case or a commercial matter or a matter involving professional negligence. Sometimes you can tell from the type of parties there are, but sometimes you can't. But the court information will give you, ahead of trying to contact the attorneys, information on the status of the case. There may or may not be information on additional parties that did not show up in the order. There's usually John Doe's, ABC, XYZ, John Doe's and John Doe corporations listed in the court information that may or may not be in the information that you get. So I always go to the court website and find out what that tells me. One thing that does tell me that you don't get otherwise that's very important is it gives you the then current discovery end date, which is in the current court program, sort of the date that the court wants the mediation to be concluded. Years ago, the court thought the mediation should be done in 90 days after the mediation referral order was sent out. And the mediation order is sent out frequently before all the parties are joined in the case. So that was a glitch in the system. Now I think, you know, and I want to talk about the importance of getting the mediation done as promptly as you can, but the window of time that we have to work the case with the parties extends now. The expectation is that it will extend through the discovery end. So I gather information. My initial contact with the parties is typically a letter of introduction. Again, if it's a private mediation, I had a conference call and I follow that up with an agreement to mediate, reflecting the terms. We may have already decided on mediation date and those kinds of things. We may not. That, you know, really depends on. I have some competition here. Sorry. Oh, I'm sorry. I thought somebody was speaking to me from above. So my initial contact in the court case is a letter of introduction to the parties. And what I do in there is cover, I mention the appointment, I send them a one-page bio about me, I send them a copy of the order, assuming they haven't read it when they got it from the court. I also assume they don't read it when I send it to them. But anyway, just as a matter of just for their ready reference, I send that. And I schedule a conference call. And the way I schedule a conference call, and it generally works so that I don't have to deal with 19 different changes to when the conference call is going to happen. I set a time, I set a date, and I ask the parties to confer. And if the parties consent to change the date and time of the call, to give me 3 dates and times when both or all of the parties are available for the call. So I let them talk to each other about rescheduling the call before they talk to me. Sometimes they don't read that part of the letter and they call me and say, you know, Ms. Smith can't make the conference call. So usually I just take it upon myself to generate a bunch of emails to reschedule it. I mentioned the court doesn't give you emails, the online lawyer's diary, or you can, most lawyers and law firms, if you just Google the name of the firm, you'll get something that may have an email address that will get you in the right place, get you to the attorneys. I do send a letter, typed letter with a stamp on it, on letterhead, but I scan that and copy it and send it by email too. I do both just in case. Some people don't have email, pro se parties frequently, you don't have email addresses for. So, and I talk a little bit about the mediation process. I talk about what I want to do on the conference call, what my agenda for the conference call is. And I make any disclosures that have to be made. Under the court rules and under the standards of conduct of mediators, you've got to disclose relationships and give the parties an opportunity to waive them if they so choose to waive them, or to tell you they don't want you as a mediator if they don't want to waive the conflict. So I do a sole practitioner, so I don't have a large or complicated conflict check system. And I've been doing this I've been mediating for 30 years. So between mediating and arbitrating, as Gabrielle said, I've done a lot of cases, and I don't have real good records about the cases I did 20 years ago. But if I remember a relationship, I'll mention it. If I know a firm, if it's a construction case and one of the lawyers and I, attend these kinds of meetings for the construction law section, I'll mention that. Certainly, if I know about any prior work I've done with the firm, against the firm, as a neutral for the firm, I'll mention all of those things as well. That's usually less of an issue in mediation than it is in arbitration. Lawyers tend to be more stickler about prior relationships when you're going to be a decision maker in a binding arbitration situation. But that's another topic that I cover. I also now cover, and this is a funny story, the old form of order from the court. When the court assigned you as the mediator, or me as the mediator, the order said, Rick Steen's your mediator. Somewhere in the order it announced what my hourly rate is, posted on the judiciary website. When they changed the order so that I'm only appointed if the parties don't pick somebody else within 2 weeks, which I think was done, I don't know, 5 or 6 years ago, I lost track of time. If you check the order, it no longer identifies, it no longer includes your hourly rate. So I probably did 15 or 20 mediations. I sent letters out, and at one point I was sitting with somebody in a mediation session, and they said, by the way, what's your hourly rate? And I said, isn't it in the order? And I didn't say that, but I told them what it was, and then I went back and checked. It's not in the order anymore. So I put that in the letter now as well. So it's the disclosures, the rate. I refer them to the judiciary website and tell them about all the good information there is there on the mediation program and on mediators. There's a small 50-word summary of my experience if they go find me on the roster of mediators website, but I've given them a bio anyway. So that's typically most of the letter. The agenda for the meeting, I invite them to add things to the agenda if they want to. I invite them to suggest something different. I'll talk a little bit later about the control or lack of control that we have as mediators of the process. But schedule the call frequently. The result of the call is there's another call scheduled after some other things happen when you find out about the status of the case. Sometimes in some cases, depending on I guess I'm not sure what it depends on. In some cases, I have a sense that I want to talk to each of the lawyers individually before the conference call, and I will do that. I won't do that in every case, but in some cases I will. I will certainly call them individually in advance of a mediation session. Typically after the mediation memos come in terms of trying to plan. And I talk on the call, the agenda on the call itself, I talk about what I'd like in terms of the content of the memos, those kinds of things. So that brings me, I guess, to a substantive topic I want to cover, which is your role as an educator. We all have a job as mediators to explain what mediation is to the parties and to the lawyers. Lawyers in New Jersey now have had exposure to this for 15, 20 years. So the education component for the lawyers isn't as important. There are some key elements that you do want to do. I don't spend a lot of time talking about my style. I give them a chance to ask me about it, certainly at various points in time. But educating the parties about the court's mediation program. I usually try to give the lawyers a little pat on the back for having fully explained what at the opening and the mediation session. I give the lawyers a pat on the back having adequately explained the process to their client. Now, they may have done that or they may not have, but it's, an attaboy never hurts in that kind of a situation. So you talk about the program, the mediation process, everybody's role, your authority, or lack thereof, and discuss confidentiality, discuss privilege, discuss the ability in the mediation process to, and this educator function is one of the hats you wear throughout the process, not just on the initial call, certainly in the opening session, in the opening of a mediation session. During a mediation session, you may have to put this hat back on to remind the parties about something. But point out that it's off the record, it's confidential. It's not absolutely confidential. There are certain things about future harm, threats of future harm that you're obligated to report that aren't confidential. I usually don't go into detail about that. I just say something like, you know, unless you're going to do something bad, it's confidential. Unless you tell me you're going to do something bad. So they just don't tell me. Works out pretty well. But so you talk about confidentiality, ex parte. There are still a number of lawyers I run into who think that mediation has to be done, you know, not on an ex parte basis. Most of them are comfortable with that concept now, but particularly in the context of caucuses and all, you know, you're allowed to meet separately with people, but that's something that is a lot of lawyers are still not used to, even after all the years that we have been mediating. So your role as an educator is throughout the process. And that's a good way, if you have a good manner of presenting and educating in a not in a formal manner, but in a friendly manner, and maybe put a little humor into it if that's your style. That's one very important element in getting the part, you know, engendering the trust of the parties, which you're going to need at some point in the process, and certainly the trust of counsel. So the way you do this and your comfort level with that, certainly your knowledge about what's involved, is important in being able to talk to the parties toward the end of the day. Sometimes in a matter, in a style of being an agent of reality, when the reality is not something that that party may want to necessarily hear. So the other part of it is one of your roles, certainly, is the process manager. So you guide the parties. I tell the parties, and the mediation is the party's process. It's the party's process in terms, certainly in terms of the outcome. They have the ultimate say in the outcome, whether there's a settlement, whether there's not a settlement, whether they stay in the mediation, at least beyond the hour. Even when people are in mediation, if it's not under the court program, sometimes there's, you know, a time limit that they set, either arbitrarily or otherwise. A lot of that is just negotiating tactics, but sometimes you need to, I always ask at the beginning of a session whether anybody has commitments later on in the day. Unlike family mediation, which tends to be done in discrete segments of time, hour and a half, 2 hours, whatever. There's an appointment and there's a start time and a set end time for that session, and then there's, you know, maybe 3, 4, 5 more sessions. Civil mediation tends to be you start when you start and you stop when it's done. And that can be the same day, that can be that night, that can be the next morning, that can be adjourn and come back in 2 weeks and resume, or come back in 6 months and resume. So the timing on the day of a mediation, I ask people, particularly if there's people from out of town, you know, whether they have any commitments later on in the day, because I want to know how the timing of things, how I have to pace things, or how the parties have to pace things. If I know that somebody has to leave at 3 o'clock to catch a plane to go back to wherever, I want to know that, so I know that that's a hard deadline, that I have to have either have the case resolved or I have to have a plan to go forward from that time on. about what's next, who does what next, where we, whether we're going to get back together. So I asked, and somebody, if evening, I try not to have an evening commitment on a day that I mediate. I had an arbitration hearing today, but that was, that's scheduled. It was over at 4, so it was over. But sometimes people will tell you if they have one. Sometimes they'll just keep that in their back pocket, and at 3:30 in the afternoon, suddenly somebody will say, "Oh, I gotta go, do this, do that, something else. I have to go," and they haven't told you. They just leave. So then you're scrambling to figure out how to wrap up and get the parties to the next step, or wrap up with a much quicker resolution than I was planning. So the process manager is it's the party's process. I tell them how I want the how I typically have a mediation unfold, and then I ask them if they're okay with that. Not constant, but frequent buy-in, getting the parties to think about what's happening and getting them to think about whether they like what's happening or not, or want something else to happen. It is something that I found that's very useful. Number one, at the end of a whole bunch of time spent, they can't start the whine that it wasn't going, it didn't happen the way they wanted to. If I've asked them 3 times over the course of a 5-hour period whether they're okay with the way things are unfolding. Sometimes they will anyway, but not usually. So they are in control of the process as well. Ultimately, you are obliged to assess the readiness and the capacity of the parties to understand the process, to participate in formulating options. Parties may be capable of formulating options. They may not be willing to do that. They may not be willing to do that in a joint session. They may need to do that in a caucus. So, and again, each case is different, and each party and each lawyer are different. But, one of the things is, and this is an obligation under the mediator standard of conduct, is to make sure that the parties know what's going on and are competent. I've had parties who were, I've heard stories, parties came back after lunch and had gone out and had a number of martinis at lunch and were no longer competent to do anything. But that hasn't actually happened to me that I'm aware of. But sometimes, and again, typically in a commercial mediation, counsel for the parties, if they have counsel, will be present at the mediation. Not necessarily as frequently in family mediation. Family mediation more often, I think more often than not, since I don't do it, I can't really say. Frequently in family mediation, the lawyers are not present at the mediation session. If there are lawyers, unless the party's pro se, the lawyers come to the civil mediation sessions and they participate. And you have to make sure that they have the capacity to understand what's going on as well sometimes. Yes.
I've had a couple of times where I have the attorneys suddenly trying to take over the mediation. Have you ever had?
The question is, attorneys who are trying to take over the mediation, are they trying to take over your role as the mediator? Or are they trying to
I would say they were just sort of dominating on the issues and bringing it in and pulling it towards their maybe even their corner, but it's definitely that I've had trouble with. I mean, I've been able to stop it, but they just take, I'm the attorney, especially with like I've had one person being pro se and one person have the attorney, and the attorney tends to dominate.
Yeah, if you have a pro se, well, some attorneys are very aggressive, at least at the outset. In a joint session, you don't always have to have a joint session, but we can talk about that later if the parties don't want it. The attorneys and the parties, one of the things that I've learned in some cases the hard way is that everybody will try to co-opt you. They will try to get you on their side. For some reason, lawyers are used to trying to convince judges and juries that their client's position is right. As a mediator, whether you think they're right or wrong hasn't got any real impact, but you know, it's good background. Some lawyers have to take a strong stand because they have the kind of a client who wants them to do that. If they can't get off of that and start to negotiate and recognize, you know, that there are concessions that have to be made to resolve the case, you know, that might not be mediation that's going to resolve. One of the things I do with pro se parties who are always asking me for legal advice, which I'm certainly not allowed to give them, is if there's an attorney on the other side and the pro se poses a question that invites a legal opinion or a legal answer, I'll ask the lawyer to answer. They're not going to answer it wrong because I'm listening too. They're not going to blow smoke in the eyes of the pro se party, but that way I don't have to answer it since that's not my role. And usually the attorneys are willing to do that to a degree. If it's very complicated, they won't. But sometimes I back them up in terms of, you know, confirming that's my understanding as well. But that's certainly, I don't consider that giving legal advice. So keeping in mind all of the time that everybody has to be competent, they have to be focused, they have to be aware, recognizing the developing impasse. Now that again gets into the substance frequently, maybe on a particular issue, maybe just the relationship of the parties. This is not supposed to be a lecture on resolving impasses, but one of the things that generally leads to an impasse is that if the parties, either the parties aren't focused, the right party's not in the room. That frequently happens when there are carriers and adjusters who are in Minnesota or Ohio or North Carolina, who aren't going to come to New Jersey, although the court rule implies that as a mediator I can demand somebody with settlement authority show up. Adjusters, if they actually showed up at all of the mediations they were responsible for, would be doing nothing except going around the country going to mediations every day. They couldn't do any of their regular work. I do try, however, this is just, I guess, a helpful hint. If I know, because I've covered on the conference call, who's going to be at the mediation and who, you know, and is there a carrier, and so I find that's all my investigation. I do ask to be able to speak with the decision maker. If they're not in the room, I ask ask ahead of time. One of the conditions for not requiring them to be there is that the lawyer will let me talk to them, and the lawyer won't filter everything I say back through them. And that I've generally been able to do that. Once in a while, the lawyer will say, well, sure, you can talk to him. And then we get to the mediation, and he says, no, I'm going to go talk to him separately. So things crop up during the course of the mediation that you just have to deal with. But recognizing when something's heading toward an impasse and looking at why that happens is really the subject of another presentation. Helping the parties prepare. Again, this is usually in advance of the session. In the conference call, I ask, of course, the lawyers talk about discovery. I say, information. Usually they haven't exchanged documents yet. I try to get a mediation scheduled sometime after the documents have been exchanged before anything else happens. It doesn't always work, but sometimes it's a matter of the lawyers aren't getting the information from their own clients. And that's actually, and they're very reluctant to admit that on a conference call, but sometimes if I'm talking to them separately, I will find that out. So how's that going? Has it happened? Exchanging information, asterisk, that's not discovery, that's exchanging information. All the lawyers talk about it in terms of interrogatories, which I don't find useful in the mediation context, and I don't find very useful in the litigation context either, but that's just my personal opinion. They may need documents that if it's a commercial dispute, the documents that relate to the commercial relationship and how it started and how it went and where it fell apart. sometimes parties need, particularly carriers, they may need an expert report. They may need, they'll tell you they'll need a deposition. I can usually talk them out of that. But sometimes, the attorney will say, I need the deposition of the plaintiff. And sometimes when I suggest, might be a good idea to have the mediation session and you can sit there and eyeball the plaintiff and see what you think of them as, a potential witness without having to take a deposition and without having to postpone the mediation for 4 months until the deposition process gets started. I ask about prior settlement discussions, and I always ask, I frequently get a different version from each side. If they had just, if they had no discussions, it's easy. We haven't talked. Fine. Ask one side. Prior discussions. Well, they offered 100 and our demand was 800. And you talk to the other side and they said, our demand was $1 million and they offered me $600,000. You guys talking about the same case? And really, it's amazing how different their impressions are of what they've done to date. And I'm just doing it mainly because I try to get the process going without having to renegotiate things that the lawyers have already conceded. If the lawyers know about the case, as much as they know about the case, or as little as they know about the case, if they've had some discussions, I'd like to build on them rather than having to redo all of that work. Sometimes I can, sometimes I can't. I have actually been in mediation sessions where there's been a number of moves made and one party learns something that makes us recast the whole situation. I was in a mediation recently where one of the parties represented that something had, there was a construction case, there was some defect, and it was going to cost, $60,000 to repair. And lo and behold, the other party found out, while I wasn't in the caucus with them, I was in the caucus with the party who made this statement that, that was the cost estimate to fix it. That it had already been fixed, and it cost like $12,000. So, and this was in the afternoon after parties have been conceding, they're trading off things. So just the fact that was a significant enough misrepresentation that it allowed the parties didn't leave in a huff, which I was surprised they didn't, but it allowed me to get the parties to reset the parameters of the negotiation, because we're talking about a $12,000 issue rather than a $60,000 issue. So that worked. They weren't happy that they were lied to, but a good friend of mine many years ago when I started doing mediation said many lawyers think the mediator is just another person to lie to. And since it's all confidential and off the record, it's not gonna come back and haunt anybody in the litigation, certainly. I don't find that most counsel actually do that. In fact, the lawyer for this guy who made this statement was appalled because it caught the lawyer off guard too. He was mortified. But anyway. So helping the parties prepare the exchange of information, and that's where it may take 2 or 3 conference calls. The other thing that may take 2 or 3 conference calls to make sure, and if a defendant or if a carrier needs a report, if they need something to be able to adequately evaluate the case, I don't see any reason to try to rush things so that they sit down before that happens. I know a lot of times early on in the mediation program in the court, it was kind of like, we have to hurry up and do it. Talk to them about the advantage of mediating before you spend a lot on discovery, but if somebody needs some information, I got a case scheduled for May 1st, and leading up to it, there was an expert report that had to be, or there was a site inspection that had to be done, an expert report that had to be included with the mediation memos, and one of the lawyers said, I get this expert report, I can't mediate in a week, my people have to look at it, et cetera, et cetera. So we just adjourned the mediation for a month. But I encourage the parties to go as soon as I can, as soon as they believe they are able, and I try to get them to speed up the process or to shorten the time period between when we're talking and when the mediation takes place to the extent I can. So that's the exchanging information, identifying attendees. Again, you can do that, and that may change depending on how the case spins out. One of the other things that usually causes multiple conference calls to be required is when additional parties are being joined in the case. Sometimes the need to add a party that need isn't identified at the beginning of the case. It may be identified through the exchange of documents or something. So if more parties have to get in the case, it's a matter of giving time for the process of complaint and answer, although I've gotten parties into mediation before they've had to file an answer, because if the case settles, they don't have to spend the money to file an answer. It doesn't always happen, but it's worth exploring. I've had discussions with in-house counsel who haven't hired outside counsel yet. I've had discussions with insurance adjusters who haven't assigned the case to counsel yet, haven't formally entered the case, formally answered. So all of those things can happen. So identifying the attendees and their roles and identifying what else has to have the logistics of the session are the last two elements of the preparation. How are we on time, Carl? Are there any questions so far? Anybody piping up?
I have a couple of questions. One is there's a trend towards having no joint session at all in mediation. What do you think of that trend?
I have not bought into that concept. I know there are very well respected and very successful mediators who never put the parties together. To the extent that it's a business dispute where the parties don't have to, may not ever, they come into the mediation not trusting each other, they may not ever trust each other, they may not believe a single thing either one of them says, and there's no way to patch up the relationship and move forward if it's strictly, a money issue or money dispute. There may not be a need for them to spend time together. I still think it's important, though, to have the opening session together. I have a handful of occasions where lawyers have convinced me the parties really don't want to see each other. There's that kind of hostility, and that's an emotional. It's not. It has nothing to do with the merits of the case. It's just a personal dislike or, something like that. I had a mediation where two business people, they had been, they weren't partners, but they were in some joint ventures together, and in the midst of their relationship falling apart, they had some financial disputes, and they wanted to settle the financial disputes, and they didn't want to even look at each other, so they were never in the same room. But I don't know what the advantage is of having the parties do everything in caucus. I don't think that, I haven't found that particularly useful, except in the occasions. Yeah.
Will you stay in the mediation session as long as the parties want? I'm going to say it goes 3 hours, 4 hours, 5 hours. If the parties want, will you call in for food? Or
I think I've had several go into late in the evening, and yeah, I'll stay as long as the parties. I mean, if I think the parties are spinning their wheels, I'll try to get the process changed, or I may suggest an adjournment. But if the parties are working hard and they're making progress towards something, hopefully settlement, I will stay. I've pulled a couple of all-nighters, not too many, but it's hard, 11 o'clock at night, you're walking around picking up the stale bagels from, you know, the morning breakfast snack that was provided, that gets pretty bad. But you can call in for food, or you can break for an hour and go get some food. But, you know, again, if the parties are intent on getting it done then, and they're doing the work that has to be done, I'll stay and do that.
Another question is that they've reached an agreement.
Mhm.
They want to reduce it to writing.
Mhm.
Will you do the writing?
I will do the writing. I will write down things, words that the lawyers are telling me. I won't create wording on my own. I will usually ask, if it looks like he's going to settle, I'll ask early on. You know, you spend 6 hours talking about money, and you come to a number, and then all of a sudden parties need releases, and then this and that and the other thing. So I try to get the lawyers thinking about that. That's a good thing to do when you're in caucus with one side, is tell the other side, give me your laundry list of all the other elements besides the dollars. I know mediators who come to mediations with printed out forms that, you know, there's a blank for the dollars. I don't do that. I know lawyers that come to mediations with printed out forms, and that's fine. I don't have a problem with that. I had one lawyer who I tasked with drafting the agreement, and he wasn't doing it, and he wasn't doing it, and he wasn't doing it, and it turned out he had a problem. He had a physical problem writing. He couldn't write legibly. I don't know what the problem was, but did I feel like an idiot? Anyway, the other lawyer knew that.
What do you do when one of the parties is tardy in getting the discovery done? Is there anything you can do?
Other than adjourning, is there anything? You have no authority. You're not like a special master who can order parties to do anything. You have no portfolio. You have no authority. If the party, it's the same thing as if the party isn't cooperating on getting on the call or agreeing to schedule a mediation session. If a party isn't cooperating, other than you know, sweet talking them into doing something they don't want to do, I'm not sure. You can't sanction them. You can't, you know, that sort of thing. The other attorney can take action in court if there are, you know, discovery deadlines that are being met. The other attorney can make a motion for sanctions or a motion to, you know, whatever, all the different kinds of motions they can do. But as mediator, you don't have any authority to do that.
About a year ago, the ADA released a report dealing with, among other things, caucusing in civil and divorce mediation. And the conclusion was, after they researched this with all the literature, that caucusing was either ineffective or actually harmful to a mediation. Does that surprise you?
I have not read it. I don't know what the how they decided harmful. I do recognize that it's very important when you're doing caucusing to make sure that the party who you're not with doesn't get, number one, suspicious that something is going on behind their back. Number two, you balance the amount of time you take with each side. You don't leave one side sitting for a long period of time, either stewing or doing something unrelated to the mediation. So you kind of have to balance that. And I still find that if I go into, if I decide to have a caucus because there's something that needs to be done in caucus, I'll call a caucus, have that done. I won't call a caucus just because I don't know what else to do. But I have not found that that part of the process itself has necessarily caused harm in most cases. It allows you to coach the parties about their bargaining, you know, the moves they're making, the bargaining, and allows you to talk with one party about the weaknesses of their case without telling the other party essentially what the strengths of their case are. You know, so there's a lot I think there's a lot to be done in caucus. The kind of cases I do, I would not agree that there's excessive harm, unless you don't do it right, unless you do it, unbalanced, and anything you do unbalanced, anything that you do that, appears to be biased is not something that, that's not going to endear the parties to you. It's not going to endear the parties to the process. So helping them to prepare, again, typically in advance, mediation memoranda. Now there's a wide variety of views about how to do that, what to do, how much to do. The court says a 10-page something or other. What the contents are. I try to get the parties to put in there. I try to get them thinking about what their interests are. I don't need a copy of their complaint, although sometimes that's what you get, depending on the case, depending on the lawyer. If they won't share with me, if they don't know their interests or won't share them with me in advance, then they're not in the memorandum. The length, again, depends on the size, nature of the case, number of parties, what has been done in the meantime. If it's a large case, the parties may want me to look at a lot of substantive material. If they want me to do that, and it's a court-referred case, and I have nominally an hour that I'm not going to charge them for, I will clear in advance. And in one of the things on the website, if some of you haven't seen, although it's been around for a long time, are there's something called a Mediators Toolbox, which talks a lot about the issues and how to do things and what. But if you're going to spend a noticeable amount of time in advance of a mediation session, if it's looking at large submissions, I talk to the attorneys ahead of time about making sure I'm going to get paid for that. If they want me to do it, I'll do it. If they don't want me to, and sometimes they'll send me something, and just because they want to, if they exchange them, sometimes they want the other side to see this big notebook of all this information we have, and they don't want me to read it. But I usually ask if it's going to be any substantial amount of time. I try to find out ahead of time. Nobody likes surprises. And again, the court program, there's this form you're supposed to fill out if you want to get paid for pre-mediation time. And I usually don't fill it out, but I find that to be an impediment to getting everybody comfortable and moving forward in the mediation. And I haven't had occasion to have to write off a whole lot of money that I didn't get paid because I didn't have them sign the form ahead of time. That's a little more bureaucracy than I'm comfortable with, but that's not a representative of the court when I'm saying that. That's just my private opinion. Again, I asked about prior discussions, what kinds of attachments they have. I encourage the parties to exchange them. In some practice areas, that's more common. In some parts of the country, that's more common. Or not exchange them. Trying to think where I was somewhere in the Northeast, Boston area, I think, and there was the parties were from up there. There was something in New Jersey. We were going to actually meet in New York and have the mediation. I suggested they exchange the memos. Oh no, we're not going to do that. So that part of the country, apparently that's not the way to do things. But I encourage them to exchange them just because, at least as to what's presented in the memos that I've seen, which is usually where I get most of my substantive information about the nature of the case, the parties know what I've seen. I also invite them to send me a separate confidential submission if they want to, it's just for me, that where they may give me their settlement posture, they may give me information I can use, information about that they don't want to share with the other side. So I give them that option. But if the parties don't want to exchange them, I don't usually press them for it. How are we doing on time? What do we?
You have a few minutes.
I have only a few minutes.
Only a few minutes.
I wasn't sure what the distance of an hour, 50-minute hour. So mediation day, quickly. My opening remarks, and I cover some of this with the lawyers and cover it again in the mediation session. Talk about confidentiality. that's where I say, you know, if you're going to do a bad thing, I have to rat you out. Everybody's role. This is where I don't put in the court form, which is the question mark. Billing arrangements, I do talk about what the court rules say about the fact that the parties split the fees. If it's a multi-party case, if it's a husband and wife as plaintiff, is that one party or two parties? Sometimes the lawyers get picky about that, but not usually. Yeah.
What about if you like, I had one where it was like there was a three-party case, but one really wasn't, and they were brought in, but then they didn't come. That was what had happened, but they really weren't involved. Then when we got to the final bit, one of the attorneys was, no, it was supposed to be divided three ways.
Right. Yes. So you have a nominal defendant who isn't really involved, and somebody wants them to pay a third of the bill. I think the court rule says, you know, among the parties, and if they're a named party in the case, they're a party. But I think there's some discretion on the mediator's part to make a decision about how to sort out the bill. And if the parties or counsel have a problem with that, they have to go to court and get the court to recast the bill. And I've never had anybody do that I can recall. I can recall having discussions about, you know, one lawyer is representing, you know, an entity and the principal of that entity. You know, how many parties is that? If there are separate, you know, if there's a separate consumer fraud count against the individual and contract counts against the entity, are they two parties? You know, it may come up, it may not. I usually just, you know, number of parties divided by.
My brain is old, but in this particular case, I think I mentioned at the beginning of the mediation, the two parties that were there actually agreed the third party really wasn't involved. And then when it came at the end, the attorney was like, no, they're supposed to still pay a third of this mediation.
Right. Yeah. They don't have to show up, but they have to pay. And you know, parties. I've had complex multi-party mediations where you know, parties don't all settle at the same time. You get rid of some parties early on. You know, you either get all the major players together and try to settle that, or if there's a bunch of tangential parties, you know, you just get rid of them as the day goes by. And then, you know, at what point, when they settle and leave, they're no longer a sixth or a fifth of the fee. So you get, I'm not that good at math, but I have a good computer that I can tell, you know, down to the 50 cents an hour who gets what for how much of the time. People who come in late are still obligated for, you know, whatever the fee. They don't get 2 free hours just because they came in late. That's clear in the information. So let me just go through this quickly. Party openings. There's been a definite change that I've seen in how much time and effort lawyers and parties want to devote to an opening statement. You know, I've had PowerPoint presentations. I think the longest opening, the longest round of opening statements I've had was a day and a half. Wow. And that was too long. It was a 3-day mediation, a day and a half of opening. And you know, there were 9 parties, and they all said basically, you know, one plaintiff's expert said this happened, and the 8 defendants experts each said something different happened. So anyway, frequently now they're abbreviated. You know, again, it depends on what the lawyers want to do. I've had cases where, you know, there's a state agency is a party, and you know, the lawyers want to demonstrate they have a meritorious case, so they put on a substantive presentation that's persuasive and graphics and PowerPoint or whatever. And then I've had other lawyers come in and say, "You read the mediation memos, or you know, you read the complaint. You know why we're here." So, but I think the trend, and I don't know again if this is just New Jersey or nationally, is to have shorter or even no opening statements. People just want to get right to it. I don't know if anybody else's experience on the computer, anybody has any other information to shed on that or not. Were there any other questions at this stage?
Yes, I had a question.
Yes.
It concerns, how have you handled when a client, one of the parties leaves the mediation?
Is there a two-party mediation?
Of course, it's a two-party mediation. Do you try to keep them there, or you just say, hey, this is over for today, period?
It depends why they're leaving. If they're leaving because it's evident to them and to me that there's no reason to stay, I won't try to force them to stay. If they're leaving because they don't have all the information, or if I think there's some utility in having them stay, I will try to convince them to stay. But if I don't think it's going to go anywhere, and if they don't want to stay, then I may suggest that we at least confer in a week or so and figure out if anything has changed that makes it worth them getting back together. And sometimes I've talked people into staying, but I don't always try, because I don't always see there's going to be a lot of utility in it. And so I'm not always right about that either. So, the only other thing I wanted to cover, and this is really a summary, and this is what I've learned in some cases the hard way, and this kind of wraps up everything I've said. The parties understand the process and the alternatives, and they really understand what's involved in the alternatives. Most parties and lawyers haven't done a real litigation budget at the time of the mediation. Just making them do that may be all the reality testing that you need to do. So they understand the process and they understand the alternatives. They have the information to negotiate. Again, they need what they need. I try not to have them run rampant with documents and things, but if they need something, they need something. And mediation isn't going to go anywhere until that happens. It has to happen first. That's all. Parties have confidence in the mediator. That's a given. Again, that's your ability to get the parties to trust you, and the parties will consider a fair and reasonable solution. That's the one that gets you every time. I have a few more slides, but I can stop now. Yes?
Yeah, quick question about style. And one of the things that I hear from a lot of our peers has to do with the extent to which a mediator is either evaluative and or directive. I know some mediators who will tell you that they use a kind of an interest-based approach, that they're not directive. And then when you hear the stories of cases that they've mediated, disputes they've done, it sounds like they are highly directive. I'm curious about your own experience and your own take on that.
I start out facilitating, and I keep facilitating as long as that's working. Sometimes I will I'm sure most of you heard about your mediator number. If there's a technique I can use at the end of the day to get the parties who don't want to give up any more money, either out of their pocket or from getting it into their pocket, I will try to put something out on the table that if the parties agree to it, I put them out of their misery. The court mediation, your facilitative, the Uniform Mediation Act is your facilitative, and that's being an agent of reality is different than evaluating the case, I think. It depends how you do it. It's your communication skill and communication style. But I'm not a purist in the sense of, you do brainstorming, and if they're not coming up with options, are you facilitating the discussion about options by coming up with the options that's, clear as the nose on your face, those are the options. And if nobody else is coming up with them, can you, let them out of your mouth? I think you can. No reason not to. Okay. Thank you all very much for your attention. And we didn't have any dogs barking or anything in the background from participants. So everybody enjoy your evening. Thanks again.
Rick, I want to thank you very much.
You're welcome.
Let me just say, I'm Carl Cangelosi, and this is the first of our general meetings that we've had both live here at the Law Center and also as being live streamed. So we're using a webcam, the same webcam that we use for our webinars, and pretty clearly it's not good enough quality. So in the future, we'll get a webcam that's more suitable for this kind of setting. And in the future, the quality of the actual transmission will be much, much better. But of course, the substance was excellent. Thank you very much. And this will be on our YouTube channel in a few days, and we'll publicize it to everybody so they can see it as well.
And don't forget the 30th.
The
The webinar
30th.
on the 30th.
The webinar on the 30th.
Oh, yes, we have a webinar on the 30th, and it is with Tony Prinzo and Amber Leach, and it is cash flow and alimony. So, thank you.
And keep publicizing.